Welcome to Dorsey and Whitney's webinar on Can I Use This? Practical Tips for Responding to Fair Use Inquiries. I'd like to introduce Evan Everist, an associate in Dorsey's Trademark, Copyright, and Advertising Group, and Liz Buckingham, a partner in Dorsey's Trademark, Copyright, and Advertising Group, and the partner in charge of the Intellectual Property Group. I'd like to turn it over to Liz now.
Thanks, Sean. Welcome to everyone. We'll start with a few housekeeping matters. So you see you have a materials and attendance form available for download, and there we've given you the address. Please return the completed attendance form so we can make sure that you get CLE credit. For a Q&A, we ask that you submit questions using the chat function. We're going to wait till the end to address them, but please feel free to submit them as you have them during our presentation. And if we don't have time to get to your questions, you feel free to contact us after that or your trusted Dorsey contact. So as Sean said, the official title is Can I Use This? Practical Tips for Responding to Fair Use Inquiries. So that's the official title of our presentation, but the slightly more earthy, unofficial title for this presentation is based on the fact that the abbreviation for fair use is FU, which makes the unofficial title How to Avoid Fair Use Foul-ups. Why might there be a foul-up? Well, I've gotten a lot of phone calls over the years, including one last Friday at about 5 p.m. from an in-house counsel with a fair use question. These scenarios tend to have three similarities. First, there's a fact pattern involving somebody wanting to use somebody else's intellectual property. Second is there's a business person who claims that the use is fair use. And third, there's a tight deadline to decide what the heck you're going to do about the use. What could possibly go wrong in this scenario? So we're going to give you the tools to distinguish between fair use and the other FU. So we have four official goals for our presentation. First is we're going to discuss the guiding principles behind copyright fair use and trademark fair use. Two is we're going to discuss the basic elements of each type of fair use. Third is we're going to discuss some other theories of how to get around infringement claims besides fair use. And fourth, we'll identify some traps and misconceptions about fair use and hopefully arm you to have good responses when you're confronted with your next fair use inquiry. So first, we'll start with copyright fair use. What are the guiding principles? First of all, exercise caution. You should assume that every third-party work, whether it's a photo, a drawing, text, music, is subject to copyright protection and requires permission to use. Next, attribution does not equal permission. Just because someone assures you, oh yeah, no worries here, we'll give the author credit. Well, credit does not equal permission. Similarly, access does not equal permission. Just because you're told, oh, there's no problem, we found it on the internet. You know, that certainly doesn't mean you have permission. And frankly, even if you have a subscription service, it might not mean you have permission. And then the final principle is, even if you've managed to clear the work from a copyright fair use perspective, you need to consider other IP rights. For example, is there a right of publicity claim, or is there a trademark claim that could be made? And so now having given you the guiding principles, I'll turn it over to Evan to talk about the copyright basics.
Thanks, Liz. I'm going to lay a little bit of foundation for our further conversation about fair use, provide some of the basics about copyright. So what exactly does copyright protect? Well, the black letter law definition is original works of authorship that are fixed in a tangible medium of expression. So there's a few elements there. First, the work has to be original. So there has to be some level of creative spark. It can't just be a collection of facts in some non-creative format. There needs to be authorship. And we now know that that needs to be human authorship. There was a case recently where a monkey had taken a picture and that was not found to be sufficient authorship. and it needs to be in a tangible medium of expression. So that means it needs to be fixed in some format. That could be words on a page, it could be a painting on a canvas, but it could also be digital bits and bytes on a hard drive or a thumb drive. So what is infringement? Well, when you have a copyright protection, it comes with a number of exclusive rights. Those exclusive rights include the right to reproduce copies or to copy, the right to prepare derivative works, so that would be new versions or reimaginations of that original work, the right to distribute, the right to perform publicly, so for example, playing a song in public, or the right to display, for example, hanging a work of art in a public space. So a violation of any of these exclusive rights, so without permission, would likely be considered an act of infringement unless there's some sort of defense that might apply, like fair use, which we'll discuss. Other concept to keep in mind is registration. Registration is not required for copyright protection to attach. It automatically arises by operation of law when a work is fixed. However, registration is an important thing to keep in mind. You have to have a registration certificate in hand in order to actually file a federal lawsuit now. And it also provides certain presumptions of validity. So worth getting if you have any of those things in mind. So with that foundation laid, we're going to turn our conversation to fair use. So as I mentioned, fair use is actually a defense, and it's an affirmative defense, meaning that if you're the party claiming fair use, you bear the burden of proving all of the factors that are involved. And these factors are actually codified within the Copyright Act. There are 4 that I've listed here. There's the purpose and character of the use of the work that you're copying, the nature of the work that's been copied, the amount and substantiality of the work that's been copied, and the effect on the potential market for that work. I'm going to turn it over to Liz to delve into the first 2 factors.
Thanks, Evan. So the first copyright fair use factor is the purpose and character of the use. And like the 4 fair use factors, the copyright statute itself lays out what some of the favored purposes are. And I'll read them to you, and you'll see that they all tend to have a First Amendment or a non-commercial kind of theme to them. So the 6 favored purposes are criticism, comment, news reporting, teaching, scholarship, or research. And so the Supreme Court, having looked at those, has come up with a presumption that if it's commercial use that you're proposing, the presumption is against fair use. Now, the modern application of this factor, the purpose and character of use factor, focuses mostly on whether the use is transformative in nature. So that means, are you using the work for its original purpose or some other purpose? And for those of you who've ever read any copyright decisions that involve fair use, you will know that this factor is the one that takes up the most space and page numbers in the decisions. And I'm going to highlight 4 different cases and discuss why they came out the way they did on transformative use to give you a flavor of what the cases are like. And so the first case is Dr. Seuss Enterprises versus Comic Mix. So as you see here, we've got the images. And just as an aside, we have the images because this is a teaching moment, and frankly, because I don't think there's a way, these are absolutely essential to the discussion of the cases. You can't understand whether the use was transformative or not, and I describe the elements of them unless you're actually looking at the images themselves. So on the left, you'll see the Dr. Seuss work that was owned by the plaintiff. And what the defendant did is create a mashup of Dr. Seuss with Star Trek. Dr. Seuss was not amused and sued, and the Ninth Circuit found that the mashup was not transformative. So they took a look and they said, this is really a commercial use. And they have kind of a fun quote: although Comic Mix's work need not boldly go where no one has gone before, its repackaging, copying, and lack of critique of Seuss, coupled with a commercial use, do not result in a transformative use. So purely commercial found, not transformative. And now we'll shift our attention to a Seventh Circuit decision, the Kienitz versus Scani nation case. And here, if you look at the image on the left, that's a photograph of the mayor of Madison, Wisconsin. He got himself in some hot water when he tried to shut down a popular block party. And so what the defendant did is take his image, as you can see, make a bit of a statement about it, sorry for partying, and change the image and put them on t-shirts and sold them. And so the owner of the copyright, the photographer who owned the image on the left, sued. The defendant claimed fair use, and here the Seventh Circuit found that the use was a transformative use, had a different purpose, wasn't just an image of the mayor, it was criticism. And that's one of the enumerated non-commercial purposes in the Copyright Act, so it was found to be a transformative use. The next case, we'll shift to the Second Circuit, and this one involved the appropriation artist Richard Prince, who took the original image on the left and made some slight changes and added collage images to create the image on the right. In reviewing this transformation, the Second Circuit found that, yes, it was actually a transformation because of the changes in composition, presentation, scale, color palette, and media. And so that did pass muster, which takes us to the fourth case, which is also a Second Circuit case, and one that was not found to be transformative use. And here it involves our local hometown hero Prince and the Andy Warhol Foundation. So the Andy Warhol Foundation took Goldsmith's image of Prince and I think you would say gave it the Andy Warhol treatment, made it into many separate images and played with the colors and the shading of it. Now, some of you might think that based on what I just described in the previous Second Circuit decision, that it would be found to be a transformative use, but actually, no. Here, the Second Circuit said it wasn't transformative merely because aesthetic expression was added. They said it had no distinct artistic purpose, and there was no reason for Warhol to pick this photo as opposed to any other photo. So what kind of a conclusion can we draw from this factor and from the cases we've talked about? I think as sort of a bright line safe harbor rule for you, if your client, business person or your own company is not in the arts business, is not in the media business, and they want to, and you've got someone who wants to use and change a copyrighted work to help sell more products or services, it's safest to assume that that is not a transformative use. So that's the first factor. Moving on to the second factor, which is the nature of the copied work. Now, this one is a lot simpler to apply and one that takes up a lot less room in case law. Here, the general rule is the more creative the work, the more copyright protection it will receive, and the more transformation will be required for the use to be a fair use. So for example, if you have a nonfiction work, that gets a lot thinner protection than a fiction work. So contrast a news story versus a movie. Also, published works versus unpublished works. Unpublished works are much harder to make a fair use of than published works. So fairly straightforward factor, and on to Evan for the last two.
Thanks, Liz. Turning to the third factor, the focus is going to be on the amount and substantiality of the work that's been copied. So this is a twofold analysis. It's both qualitative and quantitative. So let's look at the second half first, quantitative. How much was actually taken? It turns out that this part of the analysis doesn't actually have much teeth here. So there's really no magic safe harbor percentage. As a practice tip, when you're thinking about this, you really want to take no more than necessary. We sometimes have clients ask, hey, can I use 5 seconds of a song or 10 seconds of a song or something like that? There's no bright line rule there. If you're using the hook or the chorus, the most well-known part of the song, that's going to be a factor that might weigh in favor against fair use. And so that really turns to the first part of the analysis here, the qualitative analysis, which looks at what exactly did you take, And the relevant focus there is, was it the heart of the work? The Supreme Court had a great case that illustrated this in practice, Harper and Row Publishers versus Nation Enterprises. In that case, Harper and Row had secured the rights for pre-publication of the book A Time to Heal, which was Gerald Ford's autobiography focusing on the pardon of Richard Nixon. And the pre-publication was to occur in Time magazine. Well, before Time could do that, Nation magazine published about 200 or 300 words of that book, and that book was several hundred pages long, so not very much. The Supreme Court said it didn't really matter that it wasn't very much because it was the heart of the work and was, quote, the most interesting and moving parts of the entire manuscript. So that was not a fair use. The fourth factor looks at the effect on the potential market for the work that's been copied. And the kind of relevant inquiry here is there a competition between the original work and the copying of that work? That could be direct competition, but it could also be competition in an actual licensed market or potential licensed market. So you got to kind of take it a couple of steps further to think through that. As an example, we'll look back to the Dr. Seuss case. The Ninth Circuit found that there was a negative impact, potential impact on the market for the Dr. Seuss book because these works were likely to appear in the same sorts of bookstores, even in the same sorts of locations in those stores, and consumers would be faced with the decision, do I buy the original or do I go with the Star Trek flavor? So they're competing directly against each other. So what does this all tell us now that we've looked at all four factors? The big takeaway is really fair use is a fact-intensive affirmative defense. There's really no guarantee of victory. In each of these decisions, there was in fact a decision, and in some cases, multiple decisions. And those represent a lot of time, energy, and resources to get to that decision. So what are some things you can keep in mind when you're thinking about fair use? Well, if you're going to make a claim of fair use, make sure you're solid on all four factors. If there's any wiggle room on one of them, maybe you reconsider your position. If there's a helpful case that's on all fours or directly analogous to your situation, and it's in your circuit, in the geographic area you're making that claim, you might be in a better position. And third, and finally, if you have time, try to get a legal opinion from outside counsel, or at least from your inside counsel, to make sure that you're on the right side of that assertion. And at the very least, if you find yourself on the wrong side, maybe that helps you avoid some sort of a willfulness claim. So I'm going to turn it over to Liz now to talk about some alternatives to claiming fair use.
Thanks, Evan. So as Evan mentioned, if you're having to claim fair use, that means you're already conceding that there would be copyright infringement, but for the fair use. And so we want to talk about a couple avenues to explore. Frankly, before you go down the fair use route with your client, these are better avenues because if you satisfy these, then there's no copyright infringement to begin with. So what am I talking about? The first one is public domain. So a work in the public domain means that it is not covered by copyright protection. Sometimes it means not anymore, and sometimes it means never. And so obviously this is a safer place to be than conceding copyright infringement, but for the fair use defense. So what would make a work be in the public domain? I'm going to talk about the three main categories. The first one is the age of the work. So if you see up there, there's the title of the F. Scott Fitzgerald work, The Great Gatsby. So this work was published before 1926. So it has now gone into the public domain. So any work published in the US before then is in the public domain and free for your use. Likewise, excuse me, there are works that are expressly dedicated to the public domain. And so for these kind of works, read the work, read the narrative around them. Copyright Commons type works where they're created with the notion that they should be freely available for all, and read the fine print to make sure that that the one you've chosen truly is. How do you know if something is in the public domain? There are categories of compilations. For example, the Smithsonian Public Domain images and the New York Times Public Domain archives are some, and certainly you can consult us if you've got other kinds of works in mind. And the final category for a public domain work is works created by the federal government. And now you'll notice that we've italicized the word federal because if it's a state or local government work, there could be copyright protection claim. There's only the automatic waiver for the federal government. So like any good doctrine, right, there are exceptions to the rule. So here, the caution is to beware of derivative works. And what do I mean by that? Well, a derivative work is a work that someone creates when they take an original work and they change it in some substantial way. So for example, you see the photograph here of George Gershwin, and I would mention here that this photograph is a licensed photograph from our Shutterstock license. Anyway, George Gershwin wrote Rhapsody in Blue. I'd say one of the most beautiful 20th century compositions ever. And that work is in the public domain because he composed it before 1926. So if all you were going to do is take his sheet music and play it for yourself in your house, you're fine. But if what you want to do is have it as use a recording of it, then the recording was made in, say, 1980, well, then you're in trouble because the owner of the copyright in the recording has a valid copyright because that is after 1926. Likewise, if you wanted to use an arrangement of that piece, so say a clarinet composition, for example, and that was created in 1970, that would likewise be a derivative work and protected by copyright. So the public domain can be a great doctrine to rely on, but you, like with fair use, you need to make sure you fit squarely within one of the buckets. So now I want to turn to the second exception to copyright infringement, and that would be if you have a license. And here I want to talk about a couple issues that have generated controversy recently relating to user-generated content and social media. The first is embedding. Courts have been divided on whether embedding is copyright infringement or not. And when I say embedding, I mean if you link to an existing post without creating a new copy. So you don't copy. So if Evan says something brilliant on Instagram, I think I'm doing an end run by just linking to his post rather than actually copying the post and putting it on my website. And for many years, the Ninth Circuit has had what they call a server rule, which has said, yeah, this sort of a practice is okay because there's no new copy being created. Now, some of the platforms that are the subject of a lot of this embedding have jumped in the fray and said, well, wait a minute, we don't agree with that. Instagram, in particular, earlier this year, was quite vocal about saying, yeah, if you post content, if Evan makes a brilliant post, Instagram gets the license to use the post, but I don't get the license. Third parties don't get a license. And there was a recent decision out of the Southern District of New York, Federal District Court, in the Nicklin versus Sinclair Broadcast Group case, where a judge looked at the Ninth Circuit server rule and rejected it. In this case, the plaintiff photographer had a picture of a starving polar bear, and the defendant had an embedded link to that image, and the photographer sued and won. And the court said here that you need to focus on the result rather than the technology used to get to the result. And what that meant was the photographer had an exclusive right to display the work. That was one of the rights that Evan listed earlier. And that right is being violated, notwithstanding the fact that I haven't violated his right to copy. His right to display stands on its own and was problematic. So embedding is a questionable legal theory to rely on, especially if you're doing it on a nationwide basis because you're online. And So what about reposting? Reposting is an even more perilous route to go because you're actually taking a copy of it. So, you know, you need to check the terms of the original content and see if they permit any sort of copying. And frankly, even if the terms do, you need to think about whether you fall within those terms. So what do we suggest the best practice for reposting is? To get a consent or a license, because, you know, even if someone has posted something wonderful about your brand, they might not intend to become the, you know, the spokesperson for your brand by your reposting it. So make sure that you're not just taking license with the so-called license. So now I want to turn it back to Evan, who's going to address how these elements all function in the world of NFTs.
Thanks, Liz. I'm going to talk a little bit about licensing and rights acquisitions in the context of this newer technology, specifically NFTs. So you may have heard this term thrown around this year, either in the news, on social media. It's been kind of all over the place. Or maybe you even had a client or an internal business client reach out to you about NFTs. This all kind of came about in March when Christie's sold a work by an artist named Beeple, and it's on the screen there. It's called The First 5,000 Days, for $69 million. And there's no physical version of this artwork. It's purely digital. And that caused a lot of buzz, both for investors, for art aficionados, but also for brands that were interested in trying to capitalize on this new buzz. So we've seen brands that have created their own NFTs for their own kind of branded products that folks can buy. And we've had clients even try to or consider purchasing NFTs that they would then use as promotional purposes. So in conventional advertising and then advertising on their social media and that sort of thing to promote their own brand. So that's an example that I want to table for a second and come back to. So what exactly is an NFT? As a really quick definition, it's a unique digital certificate that represents ownership of a unique thing. So those are kind of two separate things. There's the certificate and there's the thing. And the thing could be a song, it could be a work of digital art, but it could also be a physical object or thing as well. They're stored, and when I say stored, I mean the certificate is stored, verified, and transferred using blockchain technology. They're created, or the term of art is minted, using tamper-proof self-executing smart contracts, and those are tied to a specific blockchain set like Ethereum. So going back to the example where we had a client that was interested in using an NFT for promotional purposes, our first question was, well, what do you actually get when you buy the NFT? So we looked to the smart contract terms, and this happened to be on Ethereum. You can actually go and look at these smart contract terms on a website like etherscan.io, and if you have the address, you can actually click in and look through them. We thought, smart contract, there's got to be some terms there, right? Well, it turns out that mostly what it is coding, because they're created typically by coders or using programs that automatically generate this content. Sometimes there's something, usually the only sort of term that's in there would be about how much of a cut the artist gets on subsequent sales, which is something unique about NFTs. An artist usually gets 10% or so of every future sale of that work. But what we found is that there was no information in this case, and in a lot of cases, about what you actually get with the NFT. So we looked also to the platforms that were selling these things. And some of those platforms do have terms of use, but often the terms of use are focused more on protecting the platform itself or insulating it from liability, which makes sense rather than discussing what you get with the NFT. So what do you actually get if it's silent? Well, you're kind of back to your standard implied license considerations. You don't get an assignment because there's nothing in writing that says you get an assignment of rights. And per the Copyright Act, you have to have it in writing. And it would typically not be a commercial license because unless the situation or context says that it should be, which typically does not, you really get a personal license to enjoy, view, and download this work. So you might have paid $69 million for the thing, but that really is limited to your own personal enjoyment unless you go pay for a further license to use it for commercial purposes. I'm going to turn it back over to Liz to talk a little bit more about licenses.
And so Evan has just described a scenario where, you need to look at the fine print to make sure you understand what you're getting. And that, that takes us back to, the initial consideration is assume you don't have the rights you need unless you know that you certainly do. And so, and then the need to look at the details of a contract is always present anytime someone claims that their reason to be able to use a mark is based on the contract. And lots of times there are pitfalls, and we want to talk about a couple common pitfalls in sort of your run-of-the-mill licensed kind of images that we know from our calls from clients that business folks are often trying to use. And so what I mean is geography and commercial use. So lots of times you can have an image and want to use it, but when you look in the fine print, you find that it doesn't cover the territory that you're hoping that it will, especially if you're trying for global rights, because copyrights are typically rights by territory, and the original author may not have granted as large of a territory as your client would like. Also, there's the notion, as Evan was just talking about with NFTs, is do you have a license for commercial use? And what you see the image on the screen it's a Getty image, and it is an editorial image. So if you see we've highlighted down in the corner there, one line says editorial use only, and the other says it's editorial RF, which is their classification for it. And what does this mean? If you're not looking at the fine print, you might think, oh, it's a Getty image, it's licensed. I can use it however I want. But actually, if you go in and read the fine print, you'll see that it's limited to events or topics that are newsworthy or of general public interest. And so that eliminates a lot of proposed uses. And if you look at what the use excludes, it'll confirm this, because these newsworthy uses exclude commercial, promotional, advertorial, endorsement, advertising, gambling, betting, gaming, or other merchandising purposes. So I'm going to guess that the vast majority of the uses that our business clients are going to want to make from an image will fall into that category rather than the actual license category. So always look at the fine print, even if your business person, or perhaps especially if your business person thinks that they're covered. Now I'm going to turn it back to Evan to talk about the copyright quagmire that is music.
Thanks, Liz. Music could definitely be its own CLE and is in a lot of contexts. So we're going to just burn through a couple of examples here of what you need to think about, because there are some unique considerations when you're using music for anything. So where do we actually get music? We get it from streaming services, CDs, maybe less so these days, vinyl. And again, what do you get when you have the CD or the vinyl? Well, you get a personal right to play that music for your own enjoyment. You don't get a right to perform it publicly or use it for commercial purposes. So I'm going to walk us through kind of a shifting hypothetical to illustrate three sorts of licenses that you might need for using music. So example number one, you are the CEO, or you have a CEO that wants to give a presentation. It's going to be public in nature, and they want to come out to the song Satisfaction by the Rolling Stones. They might even have a CD, and they say, hey, can you play this for me? Well, the first question is going to be, do you have the rights from a performing rights organization to do that? So because that work would be performed publicly in that setting, you would need a license from what are called PROs to do that. The most typical ones are BMI, ASCAP, CSAC. There's a few others. If you're at an established venue, so like the Excel Center or Minneapolis Convention Center, they probably have those sort of PRO licenses in place, but worth checking and making sure that it's in the correct catalog. Satisfaction is in BMI, so if you have BMI in this case, you're covered. But if you're in an unconventional sort of venue, like maybe your office or a place that's just not used that often, you might have to secure those rights on your own. So hypothetical two, the presentation has already occurred, it's been recorded, you're going to post it on your website, and CEO says, hey, I'd really like to add the song Satisfaction over the first 2 or 3 minutes as or the first 2 or 3 minutes of that video. So in that case, you're going to need something called synchronization rights or sync rights. And it's just what it sounds like. It's a right to synchronize that song within an audio visual context. There are 2 considerations there. One is the composition rights. So who actually owns the composition, and then the rights to the master recording. Sometimes they're the same, sometimes they're different. But sometimes you have to negotiate those separately. And those sorts of licenses are usually on a one-off basis, negotiated directly with those rights holders, and the price can vary greatly depending on the nature of the use. So a third hypothetical may be less likely to occur, but for the sake of illustration, we'll go there. The CEO decides they want to use satisfaction, but they want it to be almost kind of a dramatic acting out of the lyrics of the song. It's an integral part of a portion of the presentation. They're acting out the lyrics. It's advancing some sort of dramatic vision. Well, in that case, you would need to have brand rights, and those are negotiated typically directly with a publisher or administrator of the composition rights. And like sync rights, those are negotiated on a one-off basis, and the cost can really depend on the nature of the use. Just because you have sync rights does not mean you have brand rights, and vice versa. So you need to make sure that you're locking down everything that you might need. So that wraps up our conversation about copyright. Before we move on, one other quick note. If you're unsure, make sure you just consult an expert. That's kind of the lesson in that case.
And if you can't talk the CEO out of this dramatic presentation on grounds of taste, you can always use the Copyright Act as a means of persuading them.
Exactly. I'll turn over to Liz to talk about trademarks.
Thank you. So just as we did with the copyright fair use, I'm going to take you through the guiding principles of trademark fair use. First principle is take only what you need. If all you need to use is someone's block letter mark, don't take the logo that goes with it. Do not tarnish the mark. It's certainly fair game to make an accurate comparison of the benefits of your product as compared to a competitor's brand, but don't take the brand itself and distort it or in some way make it look less attractive. That's not fair use. The third factor is it a trademark use? The use that your business person is proposing to use might simply be a descriptive use and be okay. Similarly, is the use proposed is it a generic use? Is it a use of a word that is used to describe a whole category of products, and therefore you don't need to be concerned? And finally, as is also the case with copyright fair use, consider other IP issues. Just because you've cleared the use of somebody else's brand doesn't mean that use might not raise advertising, like false advertising concerns or right of publicity concerns. So now I'm going to turn it over to Evan to talk about trademark basics.
Great. So I'll just delve into some of the real quick basics behind trademarks. So what exactly is a trademark? It's basically anything that identifies a source of goods, services, membership, or certification. So this could include kind of conventional concepts like a word mark, Coca-Cola. It could be a logo like the Nike swoosh, but it can also include other less conventional things like scents, product packaging, restaurant layout, color, think John Deere green, music, NBC chimes. What is trademark infringement? Well, it's the unauthorized use of a trademark or a confusingly similar trademark that results in confusion, deception, or misunderstanding as to the source of those goods, services, membership, or certification. Registration, just like with copyright, it's not required in order to actually obtain trademark protection. However, if you don't, your rights are going to be limited geographically to the area in which the mark is used. Federal registration provides constructive nationwide rights and also a host of other presumptive benefits, along with visibility on the federal trademark register. I'll turn over to Liz to talk about fair use.
Thanks, Evan. So there are two different kinds of trademark fair use. The first kind is what we call classic statutory fair use. And the word statutory is a clue that, yep, it appears in a statute, the federal trademark law, which is the Lanham Act. There are two kinds of statutory fair use. One is use of a party's name in his or her own business, and two is use of a term to describe the product or service or the geographic origin. So let's start with the personal name. If there's a senior user, take care. If this senior user is related to your client, really take care. There's lots of case law in this area, and it is perhaps unsurprising how much of the case law involves relatives suing each other. So one of the benefits of having lots of court decisions in an area is it gives us lots of guidance to offer to you to how to be able to make a good trademark fair use claim if you want to use a personal name and you know of somebody else who's got that brand. So what we suggest that you do in this case would be restrict the use to trade name use. So keep it as a company name. Don't make a competing product or service under that name. Also, do make a brand name, a different brand name that's wholly different from your personal name. Also, it can be useful to include a disclaimer, explaining that you're not related to this other entity. And then also helpful is to stay away from the other marks and the trade dress of the senior user. So don't take its colors, its fonts, its stylizations, its designs. Create your own identity that's wholly separate. And the only point of similarity is the personal name in the trade name. And that should help you survive a challenge. Similarly, let's talk about use of descriptive use. So if you're using a term if you want to be able to claim a defense that I'm just using this term for its dictionary definition meaning, then do that. Don't get cute. Don't add words. Don't spell it wrong. Don't give it a pronounced and exaggerated appearance, using bold characters or letters. Don't turn it into some stylization. And so to give you an illustration of a case where trademark fair use was found, if you look at the image that's just popped up, you see WD-40, right? That is the line from that bottle that pops out at you, right? You see it because it's used in a bold font and it's highlighted by the yellow design. So that pops. So what was challenged about this design was the use of the term corrosion inhibitor. And the owner of the federal registration, the inhibitor, challenges it. But the court found that, no, actually corrosion inhibitor was a dictionary definition for what the WD product did, and it wasn't sufficiently prominent, and that constituted fair use. Now, in another case, someone tried to use the words brew nut to describe their nuts, but the court was unpersuaded that this was a fair use because, unlike the WD-40 case, they used a stylized different font and they had design elements. So if you just stick to the facts, you're likely to be able to survive a fair use challenge. So I just want to make one comment about generic terms. Here, if you want to use a generic term, make sure you're sticking to the category to which it applies. And so what I mean by that is, if you want to refer to your fruit or your fruit juice as apple, and it's got an apple in it, that's just fine, because that's the generic term. But don't think that you can justify calling your technology or your mobile app Apple because there's a dictionary definition for fruit for apple. So seems obvious, but worth pointing out. So now I will turn it over to Evan, who will talk about the second kind of trademark fair use.
Thanks, Liz. So the second sort of trademark fair use is called nominative fair use. And this is based in case law as opposed to in the Lanham Act. Depending on where you are in the country, it may be an affirmative defense, or it may actually supplant the entire infringement analysis. So worth considering that. Typically, there are 3 factors in the nominative fair use consideration. So was the mark not readily identifiable? Did you take no more than necessary? And did the use not otherwise imply some sort of affiliation? And nominative fair use is used in a number of situations, but most commonly in comparative advertising. So making claims about your product versus another product, of course, making truthful claims about your product, parody, and then news reporting, so discussing products in the context of news. So looking at the first factor in a little bit more detail, was the mark not readily identifiable? So this really looks at, was there some reasonable descriptive language that was available instead of using the mark? And I've italicized reasonable there because that really is what this comes down to. So for example, you could say the professional basketball team from Chicago every single time you mean to say the Chicago Bulls, but it's way easier to say Chicago Bulls, and folks are gonna expect that you're going to say that. Similarly, German car manufacturer from Berlin, you're gonna wanna say Volkswagen instead. An example of this would be an independent car repair person who repairs Volkswagen cars. They can say, we repair Volkswagen automobiles or Volkswagen cars. They don't have to say, we repair cars made by a German manufacturer from Berlin. It just doesn't make any sense. So looking to the second factor, I'm gonna turn it over to Liz.
Thanks, Evan. So the second factor is to use no more than necessary. And as you recall, that was one of our trademark guiding principles. So if you look at the image that's about to appear, I can explain what at least one court has found that to mean. So here you see Terry Wells, and underneath her name, you see Playmate of the Year, 1981. So she was indeed the Playmate of the Year in 1981, and the Ninth Circuit found that it was a fair use for her to use that tagline underneath her name on her personal fan club. But they drew the line, and this is really hard to see, but you can see the rectangle there of the image. In the background, there's PMOY, so the acronym for Playmate of the Year, that appeared throughout the fan site. And it was obviously easier for folks to see when they were looking at it on the website than for you to see on this slide. But the court decided that that was more than was necessary and struck down that use as fair use. So similarly, taking no more than necessary means, use the plain text of a word mark versus the logo. So for example, you'd use Chicago Bulls rather than the Chicago Bulls and their Bull logo or the VW logo. And we are taking our own advice here, and we're simply describing them to you, and we're not using them because we don't need to. So the final nominative fair use factor is no affiliation. The use cannot otherwise apply an affiliation. And so what do you do to not imply an affiliation? Well, a disclaimer is often found to be an effective tool for doing that. So Evan has talked a bit about the car dealer case. And the first disclaimer here was one that was found to be effective as part of a fair use defense by an independent auto broker. We are not an authorized Lexus dealer or affiliated in any way with Lexus. We are an independent auto broker. I'll skip the second one and jump down to the third. And this one was the one from the Terry Wells case. And again, part of what the court found helped establish a fair use defense. So disclaimers can be effective, or, depending on the space, sometimes you don't have enough room for a disclaimer. If you use words like independent or unaffiliated, this can help you bolster your claim. Now I want to talk about fair use on the internet. And these are a couple examples that I think we've certainly encountered from folks asking us about, and we assume that if you haven't yet, you probably will be. First is a use of the domain name that includes a third-party brand. And there are a couple different ways that you can build a fair use defense or attack a fair use defense, depending on which party you're representing. If you are legitimately selling or discussing the product or other, then you can have a fair use defense. So for example, to keep with our Toyota motor sales case, buyalexus.com and buyerleaselexus.com were found to be appropriate exercises of fair use by this independent auto broker. And what I would say about that case is the defendant helped its own position by taking a few actions after it got the plaintiff's first demand letter, because the site originally had Toyota's copyrighted photographs of Lexus vehicles, and it had that Lexus L logo on the site. And so I think if those elements had remained on the website at the time of the litigation, the whole scheme would have been found not to have been a fair use, and those elements would have been enjoined. So besides making fair use of products you're selling, it's also possible to have a trademark fair use based more squarely on a First Amendment claim. And here I'm talking about things like class action plaintiff solicitation websites. You can use the name of the company that you're trying to gather class members to sue, or if you're a group of employees trying to organize a union, you can use the name of your employer. Also, if you have an employee gripe site, or if you're a consumer and you have a consumer gripe site about particular products that you dislike of a manufacturer. So while these defenses can seem frustratingly broad, if you are representing the company whose mark is being used, do know that yes, there are some limits to this. And I want to talk about a recent line of UDRP, domain name administrative panel decisions. So while it is possible to have legitimate gripe sites, you should also know that these gripe sites cannot just be a pretext for other commercial behavior, that combination is possible to stop. And to give you a specific example, there's the Sanofi.sucks decision, which is referenced on the slide here. What happened there was a website owner whose business model was to include, they had a bunch of domain names. What they would do is they would set up sort of vague, undated, and non-specific gripes. So the gripes on the Sanofi.sucks page weren't tied to Sanofi at all. And so they were believed to be computer generated. So the Honey Salt said, yeah, this is really, we have an open forum for criticism. And actually what the administrative panel did is look at what else they were doing on the site. And they found that there were lots of links to third-party sites, which were there really to drive traffic to the site. And then Honey Salt admitted that it had actually put up the domain name for sale. And so, the panel took a look at all the factors and said, yep, these gripes, they're just a pretext. Really, it's a classic kind of cyber squatter combination. You're just trying to drive traffic to your site and sell the domain name at an inflated price. And so the panel ordered the transfer of the domain name to the brand owner. So in certain circumstances, look critically at the First Amendment defense, because there are ways to attack it. But if it's indeed truly legitimate First Amendment, non-commercial purpose, then it likely will be fair use. In keywords, I'll address briefly, and probably many of you have been asked by clients, can I buy a competitor's keyword? And the answer is, well, yes, but. So the yes is you can buy a competitor's keyword, and merely purchasing the keyword alone and using it. So if you type in the keyword, your brand, and its advertisement will pop up, is fine. That is clearly not trademark infringement. The but depends on what else you might do with that competitor's brand. If you put the competitor's brand in the ad or the title, then the regular rules of trademark law and trademark infringement and false advertising apply. So, be careful if you're using a competitor's brand in a space that's really limited, because it's pretty hard to put in all the nuance that you will need to defend yourself from some sort of a false advertising or trademark infringement claim. And obviously you want to follow the terms of whatever advertising platform you're on. So now I want to turn it over to Evan, who will talk about another way to get around liability besides fair use.
Thanks, Liz. So just to touch briefly on licensing. So similar to the copyright context, you can license the use of a trademark. Just keep in mind the terms and the scope of that license. So really look closely at what it says, make sure you're following the manner in which that mark needs to be used, you're not exceeding the geographic scope. And then just another tip, and this is really mostly on the licensor side of things, but just be careful of creating an inadvertent franchise. And when you're entering a license relationship, those sorts of things typically arise if you've got a kind of a high level of control along with some sort of recurring payment. And they're bad because, I shouldn't say bad, but they're bad if they're inadvertently created because they have certain reporting requirements. There are certain termination rights that apply to franchisees and those sorts of things. So just keep those in mind. That really concludes our conversation for today. We have a few minutes to take some questions. And it looks like we have a few questions in the chat. So if you'll just give us a second to kind of sort through these real fast and see if we can answer some questions for you.
We got a question whether it was the Rolling Stones that are in bad taste or choosing to do a dramatic rendition of the Rolling Stones that are in bad taste. I would say that it is the latter.
Okay, so here's a question about federal works or works created by the federal government. So the question is, so let's say a White House photographer takes a picture and it's available on whitehouse.gov. Is it that situation, or does it include pictures of an event where the primary focus is an act by the federal government? So those are definitely two different things. If it's an image that's created by the federal government, so the big caveat there is the photographer is working for, employed by the federal government. There's no question that it's created in the scope of their employment. It's probably fine. But if it's a photograph taken by an independent photographer of the government event, that photographer still has a copyright interest in the photograph that they've taken.
We had another question about relating to internal use. So if you use a book on a topic and you want to train on it, how much risk is there to building a training course for internal use that teaches the content of the book? So if you buy a copy of the book for each participant, it would appear that the effect on the market would be minimal. Yeah, we would agree with that. I guess another factor to take into account is this someone who's just written a book, or is this someone who's just written a book and has a whole series of training presentations? So, if you're looking at the fourth factor, how much of an impact are you going to, is there a ready market that you're detracting from? So I would say that would be a big factor. Also, does it help if we take 2 to 3 books and create a single training course from those books, again, for internal use only? I think that's more problematic. And internal use only these days, I mean, what does that mean? Because often, it is a risk assessment. If it's just, Evan and I and 3 other people in the room and we're talking, that's one thing. But often you're you're recording it and it's online and your employees are sharing it with other people, and pretty soon it can be hard to control. And so I think the risk profile is much higher. And just as an example, I mean, we're now very scrupulous with slides here at Dorsey because people who contact us and want to make sure that we're doing the right thing. And so, you know, we are doing the right thing. So I think it's a fact intensive inquiry, and certainly we're happy to noodle through specifics of those with you. Maybe we have time for one more.
I think so. So this is a question about, so if you have permission to cite information from an article, and that specific article in turn cites to surveys, statistics from a third party, do you have permission to also use the material, the third party material in that article that you're citing? And I'd say that would depend on a few things. If the article from which you've obtained permission has the permission from that from the other article to give you permission, so they have the permission to license or give permission on their behalf, you're probably fine. The other question is kind of what does that material consist of? Is it purely factual information? Is there truly some sort of a copyright protection that's available for that information, such that you might be comfortable using it and claiming fair use, or that there's no protection for copyright? Again, that would be fact intensive depending on the nature of that content. But I think that's kind of all we have time for right now. So we'll wrap it up. If you have any questions, definitely reach out to Liz and I. We want to just take a brief moment to plug our blog, the TMCA blog. There's a URL there. You can visit it, or you can subscribe and get email blasts whenever we drop a new post. So we'd encourage you to do that.
And speaking of dropping a new post, if you were intrigued by my discussion of the Sanofi.Sucks case, I have a blog post from Tuesday that discusses more about that case. So please take a look and please subscribe, and thank you for watching us today.
Thank you.